Okay, good morning, everyone. It's 9 o'clock. Regularly scheduled management and planning meeting for 10 o'clock. We're going to precede it by this, what's going to be executive session, which is titled a little bit differently at the moment, but regardless, I guess we can say the pledge, and then we'll pledge again at the other meeting. Let's do that. Let's do that. Let's say the pledge. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Okay. Attorney Herin. Yes. I'm going to let you start this off.
I appreciate it, Mr. Mayor and members of the council. As you all are aware, two property owners have been pursuing approvals at the state and at the...
I think Jim came in after you told the rest of us.
We're not going to be having an executive session per se because there's some case law out there, recent case law that says that pre-litigation conversations aren't eligible to take place under an executive session umbrella because there has to be pending litigation. The courts have interpreted that a lawsuit has actually been filed. And while there have been many lawsuits, actual and threatened with regard to this issue, at this particular time, there is no pending litigation as that term has been defined by the courts. There has been, and there currently is the invocation of the Florida Land Use Dispute Resolution, Environmental and Land Use Dispute Resolution Act, FLUEDRA, which is really what I need guidance from you all and the whole reason why we're having this meeting. Whether it's an executive session or not, I still need guidance from you all on how the council wishes for me to proceed in dealing with the pending FLUEDRA matter. While otherwise we'd go through script here and talk about invoking the executive session and then asking the public to leave the chambers while we then conduct the executive session, that process is not available to us in the current posture of this matter. With that said, we do in fact have the FLUEDRA process to pursue, which is a mediated process where the parties have selected an impartial outside mediator who is tasked with the responsibility for conducting a public mediation where this dispute is discussed. Both sides have an opportunity to present their case and seek and determine whether or not there's any middle ground that may lead to a resolution of the matter without any further action. If the parties are successful in that mediation process, the mediator will, like in other mediation cases, put together a report. It will come back to this council for ratification and for approval, and the parties will then proceed under that mediated settlement agreement as they go forward. If the parties do not reach a mediated settlement, the mediator is tasked with the responsibility for making the determination and putting together a report, which then gets forward again to this body, saying that based upon everything that the mediator has heard and everything that he has considered, he either will make a determination that there has been a burden placed upon the property owner's rights or not. And then subject to that report, the council has the ability to potentially resolve the dispute at that point in time or not. And then last but not least, the process will have been exhausted, and under the statute, the property owner, if they are not happy with the solution that the council's put forth at the end of the day, has the right to pursue any and all legal remedies that they have or that they believe are appropriate. So that's the framework of the FLUEDRA process. As the posture from the city's standpoint, moving into the mediation currently sits, is that by a 3-2 vote, the council voted to deny the special exception application that would have granted the property owners their request for the ability to place or construct and use a dune walkover behind their property over state land. Obviously, to the extent that the parties have invoked the Fluidra process, I now need guidance whether or not that is still the position of this council, because membership has changed, and if it is, what parameters this council wishes for me to proceed in trying to seek a mediation. What are the issues that you would like me to emphasize and seek to protect or obtain a settlement and along those lines? Or alternatively, you want to proceed with the matter at all, or basically what is the position of the council, and how would you like me to move forward? I'm certainly able to answer any questions. But again, the primary issue from the staff's position and the prior council's actions is an existing determination that the applicants did not meet the criteria for the granting of the special exception.
I have a few questions, sort of preliminary before we get to the guidance issue.
Ma'am.
Did you indicate that a mediator has already been selected?
Yes, ma'am.
And who is that person?
His name is Mark Barnaby. I advised the council of Mr. Barnaby's selection, I believe, about a month ago during one of the meetings. I know I did, but it doesn't. Mr. Barnaby is an attorney who's based out of Bradenton. He practices local government law. He is a certified court mediator. He has handled these types of claims both as a mediator, as an attorney representing property owners, and as an attorney representing local governments. He is currently the city attorney, I believe, of Palmetto. So he, like myself, has a broad background in representing private property owners, local governments, and more particularly to the issue at hand, he has, in fact, been a mediator of other Fluidra cases throughout the state of Florida.
Are you the person from our side, who selected him?
The parties put forth different names, and of the names that were put forth, I agreed that Mr. Barnaby would be well suited to, in my opinion, to handle the case for. I
was just trying to verify, because we've had outside counsel in this case before.
Yes.
So you have been the person who participated.
I've been the person. Yes,
okay.
ma'am.
In my background, I've experienced with both mediation and arbitration in a different state, and in that state, arbitration has a much different meaning, and people throw the terms around interchangeably. Could you guide me a little bit? I was surprised to hear you say that this mediator gets to make a determination, because in my experience, that's what an arbitrator does, not a mediator. A mediator doesn't have any powers. And
well, the mediator, let me rephrase it, because you are correct. The mediator prepares a report based upon the results of the mediation, what he's heard through the mediation process, and he forwards that report to the town council for its consideration.
does it go to the judge in future proceedings?
It's essentially a recommendation.
Is it binding as a finding?
No.
Okay.
Ma'am.
And who are we sending as our representative to participate?
That we will. That's one of the things that I was
Okay.
as we discussed.
Caught up with you.
Yes, we do need. I do need and recommend that this council appoint one of your peers to go with us to the mediation. I would also suggest that you authorize the manager and Mr. Green to also, Jason Green, your director of community development, to attend, because those are particularly Mr. Green is the person at the staff level who has the most experience with not only the issue itself, but the underlying regulations.
We could send a whole team.
Yes, ma'am, and in fact, I suggest that we go as a team with attorney, manager, that, at your discretion, but certainly Mr. Green and one of you.
And is there a lead that gets to control the team?
I certainly take my direction from you all. Always have and always will.
I just have a procedural question as well along the lines of the Vice Mayor. So we enter into this a non-binding arbitration,
Mediation.
non-binding mediation process. And then if we can't reach agreement, and the mediator puts forth a report as to which side they would take, you got me a little confused on that.
There are, under the statute, there are two reports that the mediator potentially prepares. One, mediated settlement, if the parties come to an agreement, which then will come to the entire council for your approval. The parties cannot come to a mediated settlement, and the mediator will prepare a report, a recommendation as to whether or not, based upon the outcome or not the outcome, but what he has heard during the course of the mediation, whether or not he believes that the government regulations as applied to the particular facts, circumstances, potentially amounts to an undue burden on the property owner's rights. The council will receive that report, can decide to take action on it or not, or no action, and then the matter would potentially be ripe for the property owner to bring legal action if they so choose.
So then the applicant has at that point utilized all administrative remedies and then can go to court.
The process has been exhausted.
Got it. So this if they don't, if the parties don't come to an agreement, the mediator puts forth a report saying that or she or he does not believe that this was a burden, or does believe it's a burden on the applicant. And let's say that the mediator concurs that it is a burden on the applicant. Is that a sort of a tip of the hat to the council that we have litigation exposure?
No, that's up to you all to decide. But to the question that was asked by the Vice Mayor, that report does not become part of any litigation.
I appreciate
It's for you all to consider and use.
Clarion call that we have potential exposure. Fair? Could be.
Could be, yes. Without, there's somewhat a certain degree of this discussion looking into a crystal ball. But certainly I would suggest to you that if the mediator does in fact come back with a report that says that there's been an undue burden, I think that any property owner, not necessarily in this situation, but any property owner with that kind of report is going to be
Empowered?
not empowered, emboldened. Not empowered, because it's not an empowerment, but
Encouraged or
emboldened to
emboldened, yeah.
potentially pursue legal remedies.
Is there a time frame that this all has to be done within?
We're actually beyond the time frames that are specified by the statute because, frankly, the COVID-19 situation. The parties have already waived the time frames, but there still are some time frames in with respect to the time after which the mediator is supposed to either submit a proposed settlement agreement that the parties may have reached, or alternatively, that second report of whether or not there's been a burden or no undue burden. And I believe, if I remember correctly, 60 days after the conclusion of the mediation.
I'm sorry.
To stay with the time element here, so 60 days after the conclusion, but is there a time limit to get to the conclusion?
We are already trying to arrange for the meeting already. So to the answer, yes, we're in the process of trying to set up the mediation date, factoring in things such as the lifting of the restrictions that the previous were in place. Anticipate. So we are looking to having this mediation in a perfect world, sometime in the middle of July.
So there's a mediation, and then there's a report written up, and then we don't know how long that takes, and then we don't know how long afterwards that's disclosed. What do we? I'm trying to figure out how long this whole
what the time
process.
frame is.
The
I
whole
would
process.
I would think that the entire process will be finished before the end of September at the latest.
And my next question along the same lines is, and I can't hold you to this, what sort of cost are we looking at to get this process done?
Obviously, the time to pay the mediator,
Right.
we split that cost with the property owner, and then the time of staff. That's it.
Well, based on your experience, a mediation of this time length, just a ballpark estimate, is it going to cost $100,000? Is it
No,
going to cost
no,
$50,000? Is it going to cost $20,000?
Less than 10.
Less than 10,000?
Yes, sir.
Forgive me, Mr. Mayor, was that the mediation process less than 10, or the whole, if we end up litigating?
No, just the mediation process.
Figured that was the case, but I'll make sure that-
This is just
envisioning-
openers.
Yep.
Now, sticking to the dollar question, what has the town expended to date on this? Now, this I probably could hold you to a pretty close number, but between the manager and the attorney, you should have a fairly good idea of what the town has expended to date on this whole boardwalk matter, crosswalk, whatever you want to call it.
The numbers I've gathered is around $250,000.
Order of
Probably closer to 225 when you factoring in the amount of money that the town has paid to the previous outside counsel, Ms. Collins, and to the town attorney for our services through the entire process.
Close to $250,000.
Yes.
Okay. All right. Any other questions?
Yes.
Yeah, one quick question. Now, you're talking about kind of procedure here. You said we are not in an executive session, right? So what we're saying now
correct.
is open to the public.
Everything is, we are transcribing it, and it is being live streamed. So there is a record of this, and unlike an executive session where this would be outside the public and the transcription would be sealed until the end of the dispute or the litigation, that's not the case. This is all open to the public.
So we're expected before this mediation to select one of our members, and also any direction we give them is public, which means that the applicants can also have access to whatever guidance we give someone we select.
Unfortunately, that is the downside to the Sunshine Law. And the ability to meet in executive session has been narrowly construed, as I've explained before, to exclude. The court has had an opportunity to already rule on the issue of these types of discussions being the subject of a shade meeting or executive session, and has ruled they are not. It must be actual litigation.
We have to decide whether or not we want to even give any guidance and tip a hand, or whether we just pick a representative and let them get the best deal they can.
That is certainly up to you all to how candid you want to be and what position you wish for me to take. I know I have spoken to many of you over the last several months on a number of occasions regarding this matter. If you want to, if it is desire of the council to continue to have those one-on-one conversations, certainly can do that. But at some point in time, I must candidly tell you, I need some basic instruction on how you wish for me to proceed going into the mediation.
Well, excuse me, just 1 second. I've taken that on as a goal right now, is you're going to get your direction today. So we've got 3 members up here that in the past have voted to approve this special exception, and 2 that have voted against it. Today, we're going to decide amongst the 5 of us how we're going to proceed. So we're going to make a decision up here today. Hey, everybody? That's
I-
Two that have
That's the
voted
goal.
against it, and we
Yeah,
don't have
I've-
two that have voted against it.
I've never voted, I've never had the opportunity to vote anything.
I'm sorry, I take that
But,
back. I
but
take
let
that
me,
back.
let me just continue what I was saying, because I think that strategically, I think it would more behoove us to communicate individually with the attorney in private when we have attorney-private privilege, so that we don't give away any of our views. He'll have all the views from all the different councils, just not in a public setting.
I agree with Bill. I think that you can't give away your hand by giving public instruction to the attorney in this matter, because then it's useless.
Attorney has asked us today whether he's
Well, I mean,
looking for guidance, whether we should continue
Yeah,
this.
And he can
I-
have that guidance from us individually, and he will know how the five of us feel one-on-one.
If it is the will of a majority of this council to say to me prior to the end of this meeting, Herin, we would like you to take action consistent with the conversations we've had with you individually, that's the direction that I will take, and that is to, and I don't want to put words in anyone's mouth, is represent the town's interests in trying to seek a settlement that is in the best interest of the town.
Just to clarify my point, they are not required to reveal to us their discussions they have with their counsel before they go to mediation. We are at a distinct disadvantage if we completely publicly discuss this, because they don't have to do what you're asking us to do.
The town attorney just told us that he's had these discussions with everybody privately. So I think he pretty much knows where everybody is. Am I putting words in your mouth?
No, this point, as of today, I can tell you all that I have a enough sense of what your concerns are and the issues that you would like me to raise during the mediation process to move forward consistent with those conversations. To the extent any of you all want to have additional conversations, I certainly will make arrangements to do so with each and every one of you as the process moves forward. And then certainly we have the team, whatever that may be, obviously has an obligation to bring back to you all whatever it is that may be a mediated settlement agreement. You, as a council as a whole, in a public meeting, have the ability at that point in time then to say yay or nay, or give me additional instructions in saying, well, Mr. Herin, we're okay with X, Y, and Z in this settlement agreement, but we'd like you to continue to work on A, B, and C, and go back and do that for us. It's a fluid process, like any litigation matter is, particularly as when it relates to trying to seek a solution to a dispute where the parties don't see eye to eye. But again, I have a general sense from talking to each and every one of you of what are the issues that you want. I think that without disclosing any of those communications improperly, I think the general consensus I can tell you from where I sit is, Mr. Herin, we would like to solve this matter without litigation, and can both parties give and some ground to seek us consensus that everyone can live with. And that is the direction that I believe I have if you were to simply say, Mr. Herin, go forth based upon the conversations that we've had with you individually.
That is not a unanimous consensus that you have received.
No,
Just to make it clear, since the public has access to this,
yes.
I don't want people that I know to have the impression that that was a unanimous consensus.
And I want to make it, again, very clear that as I understand the communications I've had with each and every one of you about this matter, it's not just simply settlement for settlement's sake. If that answers or goes to the issue of concern to some of you, there will or I will seek on your behalf, concessions from or compromise by the applicant in their position, which as I understand it, based upon communications that each one of you all received last night, which was then forwarded to me by Councilmember Atterholt, and I appreciate that, is their position is give us what we're asking for or else.
Yeah.
If I'm incorrect in that, I have reached out to their attorney to get that clarification. I have not yet received that, and that would again be part of the mediation process as we move forward.
All right, just so we're clear here. In your consultations with the 5 council members, you didn't get an impression or a consensus, kill it. You got an impression that we want to mediate this, we want to negotiate and reach a settlement before we go to trial.
Sir.
That's the impression that you,
Yes.
distinct impression that you got?
Yes.
Okay.
But it was not unanimous.
I haven't had this specific conversation with John.
Well, I'm just trying, that's what I'm trying to get a feeling here. I'm trying to get a feeling, because, I mean, I would hope if you had heard from 3 members here that said, we want to kill this thing, let's stop the bleeding now, that you would tell us that.
Yes, sir.
Okay, all right, enough.
To get back to what I was talking about this whole, before the mediation process, is that, I mean, the whole goal to go to any kind of mediation, right, is get the best deal possible going in. And that means not tipping your hand, and so we want to get the, if it's a settlement or a report, we want to get the one that's the most in our favor to come back to the council, where then we'll come up with consensus on it. Before then, it's all just negotiation. It's all just coming up with a strategy, so we go into this meeting with the best tools we have to get the best settlement or report that we can get out of this.
So is it your intention then to have another executive session before this process begins?
Unfortunately, unless the property owner formally files suit, which they have threatened, have not yet done so, we don't have the ability to meet in an executive session. We can continue to have a discussion just like we are here as additional information comes forward, and as we progress through the mediation process, I will certainly, it's my commitment to you here publicly, that I will keep each and every one of you informed of the progress of the Fluedra mediation, and to the extent that that you designate one of yourselves as part of the team, certainly I'm going to rely upon that individual council member to give me their comment and advice as we move forward.
And I'm surprised to hear you say, if they go ahead and file. I was under the impression that we were forced to go through this process before they were allowed to file.
Yes, I mean, the statute says that once Fluedra is invoked, the parties have an obligation to mediate in good faith to see if a settlement can be achieved of the dispute.
So it's not a requirement before they file?
They could always go.
And then the mediation process would not happen.
Would not happen. They've invoked it, and we have an obligation under the statute to then follow the statute. That's how the statute is written. It says that the property owner who is unhappy with the local government decision may invoke Fluedra. If they do invoke Fluedra, this is how it works.
Okay, now that they've done.
It is a non-judicial administrative process.
Now that they've invoked it, do they have to then exhaust all administrative remedies and go through that entire process to its conclusion before they can file a suit then?
Well, it is anticipated that is how the Fluedra process would work. But they could say, you know, they could send us a letter tomorrow saying we're withdrawing our invocation of Fluedra and we're going to court. And then we would have the ability, once that lawsuit is filed, we would then have the ability to meet in executive session to discuss the merits of the complaint and how we potentially could settle that dispute under the executive session umbrella.
Okay.
Mr.
Yes,
Chair, if I may,
sir.
I want to circle back. We were talking about the cost already, the money spent. I believe you started to give us an estimate of what it potentially could cost should it go to litigation.
No, once, if it's litigation, for all intents and purposes, all bets are off. It's hard for any, certainly for me, as having done and handled these types of lawsuits extensively, to give a precise number, because every piece of litigation is unique and a lot of variables. But you're certainly going to spend more money than pursuing and going through the Fledger process, which I don't think will exceed, $10,000 in fees and costs payable to the mediator and my fee to attend.
The sky's the limit on the other end, Dan.
I don't, not that I'm suggesting this is a reason why not to pursue a settlement. I think that it is always to the benefit of any of my clients, government or otherwise, to pursue and look seriously at a settlement, because settlement avoids the uncertainty of litigation. And when you do get into litigation, doesn't matter how strongly I feel or any other attorney feels about the merits of the case, you never know, because you do not control it. The judge or the jury does. With that said, until we actually receive the actual lawsuit and see what it is, there is the possibility, albeit remote, that the claim might be covered by our League of Cities policy. And they would cover both the cost of litigating it and potentially paying any monetary damages that may result from an adverse ruling. But that's speculation.
The mirror.
And that's what I want to make clear, that what that ultimate cost may be purely speculative. But we have already, over the course of 2 separate lawsuits one separate lawsuit and one administrative hearing process, and an appeal, incurred in excess of $200,000 in attorney's costs over the course of, I think, close to 3.5, 4 years of litigation.
If this were to go to litigation, is this the setting that you can inform the public what the town may or may not gain or lose should we not win the litigation?
I would advise you of that at any point in time, once the litigation is filed, is what is the downside of any litigation.
More process question, if I could, John. With respect to the mediation process, do both sides actually present their case before the mediator, or are they communicating with each other? In other words, does the mediator hear both sides? And then, again, if both sides don't reach agreements, he, in essence, in his mind, adjudicates this and makes a recommendation as to whether this is going to be a burden on the property owner? In other words, does he hear both sides in a formal sense, or is it an informal sense?
So it's formal, but attorneys make their living parsing words, and I would caution you all: there is no adjudication here. In Fledger, there's a recommendation. There's no formal determination that someone has done something wrong or done something right. It's a mediated process. It's a mediation process, which its primary purpose is to lead to a settlement. If there isn't a settlement, and only if there isn't a settlement, does the mediator then prepare a report. And he's not making any adjudication. He's just simply making a report, his view of the world.
But you say he's not making any. He, in essence, is making a recommendation as to which side he believes would prevail, correct?
That's in the eye of the beholder, and it would be really dangerous for me to speculate what may be the contents of that and how it would be. In
other words, it could be he could make a determination as to it would be a burden upon the property owner, but not much of one. And I mean, will it be that nuanced, or will he give a detailed analysis, or what's he requested under the process to do?
Unfortunately, there's the statute doesn't say. There are some basic.
What's precedent dictate?
again, there aren't a whole lot of these things out there to look at and compare ourselves. And one way of doing it and generating a report does not necessarily mean that's how every other mediator does it. Because there's no playbook by which that necessarily guides the mediator. It's at the discretion of the mediator. There have been some very detailed orders or recommendations and settlement agreements, and there's been others that are just simply, the parties agree to do this, and they're going to do it through the normal quasi-judicial process. That's it. So there's no one template that I can look to and say, this is what it's going to say, and this is how it's going to be, unfortunately. I wish there were, frankly.
Councilor Atterholt, typically what I've seen, not specifically in this process, but in other ones where you can't reach an agreement, they basically try to summarize for the elected officials key points, both pro and against, so you sort of have the benefit of having all of that mediation synthesized into a paragraph sort of representing either party's position. So when you read it, you know points, counterpoints each party is offering, so that you can then perhaps have an opportunity to reconcile those. So they're trying to, basically a day's worth of discussion into, paragraphs of here's how this party sees it, here's how this party sees it, here are the points of disagreement. In some cases they'll infer which way they're leaning, some cases they do not. The other thing, since I'm speaking, I'll just continue to say is this. The mediations that I've been in, they all come back to council for approval. I can tell you, I've brought ones forward that I thought were very fair deals when I left the mediation room, brought up to council, and they got voted down. I've had others that was a deal on the table, and I had an obligation to bring it in front of council, and I said they would never vote for it, and they did. So I've seen both ends of the spectrum as it pertains to that. But the important fact is that whatever the result is, it's going to come back to you for a decision, and that decision could very well be go back and keep working on it.
To answer the question of Councilman Atterholt very specifically, and bear with me, because I think it warrants just reading straight from the statute. The special magistrate finds that the development order or enforcement action, or the development order or enforcement action in combination with the actions or regulations of other governmental entities is unreasonable or unfairly burdens the use of the owner's property, the special magistrate, with the owner's consent, requires the property owner to say, yes, we want you to do this. He may recommend to the town council one or more alternatives that protect the public interest served by the development order or enforcement action and regulations at issue, but allow for reduced restraints on the use of the owner's real property, including but not limited to, and there's 10 specific things that the special magistrate can recommend, but he's not limited to just those 10. So again, depending upon the particular mediator and what he hears, it may be very detailed. Or otherwise it may be, I find that there's not an unfair burden placed on the property owner's property, or I do find that there's an unfair burden placed on the property owner, and the government should approve it. As simple as that.
John, you keep using the term special magistrate.
That's
For a special magistrate acting as a mediator, because a magistrate has a power to make findings.
The statute calls the mediator a special magistrate. Yeah, even though it then says this is a mediation.
Okay.
Well, I think, though, that, I'm looking at this kind of strategically, and really we have nothing to vote on now except who we want to represent us, because we're not really counting heads at this point. Until we come back with some kind of recommendation, either a settlement offer or some report that either says A or B is solid, and you have to then make a decision based on the report. Our goal at this point is just be to try to put together the team without us all tipping our hand, that will come back with the best possible settlement report for us to go forward. It is only until then that we can actually vote on what it is, because right now we don't know what it would be.
Actually, you're jumping the gun just a little bit. First, we have to have consensus up here whether we want to continue this at all to the mediation.
We don't have any choice.
We don't?
We have to participate if they invoke it.
The statute says that the parties, once the process is invoked, have an obligation to act in good faith and move forward. I'll give you my life experiences. Representing a landowner, where on behalf of the landowner, we invoke Fluedra, the local government, which is a county just a little bit to the north, turned around and said, "You're happy with our decision. We're not doing anything. See you in court." We end up in court.
Okay, that was not what I remember being told when this was first started. I seem to get the impression that we had to participate
I
once
believe that since then, they've amended the statute to add in the good faith and that you must participate in
Right.
good faith. And that's my recommendation. That's the instructions that I'm looking for from you to move forward on. I was.
You are looking for instruction.
Yes. But the extent that we move forward in good faith, in all candor, what concerns me is the email that each and one of you all received last night from the applicants. Or they, as I understand it, and this is my view, may not be yours. Please tell me if you don't agree with me, because I do want that input. Is their statement in that email was, "Give us our special exception, period, or else." That doesn't to me show good faith.
You could look at that another way, too. You could look at it not as a threatening position like you're saying. May I?
Go ahead. I'm allowed to laugh.
And I do want your comments. I want each and every one of your comments on that issue, because it's important for me to know your thought process on that. I do understand and need that input. So, Mayor, I apologize for interrupting, but please, I do want to hear what your thoughts are on that email.
Well, here's one of my thoughts, is that they're both property owners within the town of Fort Myers Beach. Let's not forget that. They both own homes right here in Fort Myers Beach. And they're looking at the expense not only on their side, but also on the expense of the town side moving forward. So there is some concern about that as well. And I happen to take that same position here. We're going to be discussing later on all these projects moving forward here, Bay Oaks, Times Square, Bay Park, Bayside Park. Meanwhile, we've already got $250,000 into this matter, and with the possibility of maybe doubling that, tripling that, who knows? Who knows? It's open-ended. So that's my concern. That's my concern. Now, my question is are there any other members here who feel the same way? If not, then let's just move on. Let's move on. Let's move on to the mediation and be done. I'm trying to cut to the chase here, and I'm sorry if I'm cutting to the chase, but that's the way I feel about this.
What you're proposing is we just grant the special exemption, don't go to mediation. We offer.
I'm looking to give John that direction. That may be the way I feel, but I'm looking to see if there's anybody else who feels the same way. If anybody else feels the same way, we stop this. Yes, we give them their special exception and we move on. So I'm looking to find that out today here. If that's not the case, then we move forward with the arbitration, the mediation, whatever you want to call it. But if there's a chance at stopping it, I want to hear about it.
And
I think the attorney does too.
I do. Because if there is a majority of this council that is willing to grant the special exception application, for lack of a better description, as is, and you know, essentially reconsider the application and vote on it and to potentially approve it, then there is no sense in moving forward with the Fluedger process if that's ultimately what the outcome is going to be. If that's the desire of the council, then as the mayor indicates, we don't have to go through the Fluedger process if that is your decision or your choice.
I'm really surprised to hear you say that, because this session was advertised as a private session where the public wasn't allowed to participate. Now, the mayor is proposing to do something completely different that's been advertised to the community, go back and grant an exception without the public being able to weigh in on that process. If we reach an agreement, the public would be able to come and tell council, yes, vote yes on this agreement, or not vote on this agreement. He's basically bypassing all public comment on the issue.
No.
I'm not.
No, it will have to come back as a public hearing with
He was saying to give you instruction today just to go ahead and grant the exception without going to mediation is what I heard him say.
no, I don't want to, I understood it, and Mayor, correct me if I'm wrong, is that we would process the application again, de novo, cannot circumvent your procedures. That's otherwise considered to be illegal contract zoning, and I would not condone that or approve that.
That's what I was saying, but that's not what I thought I heard him say.
And so in lieu of moving forward with the Fluedger mediation, we would bring the item back through the development review approval process, and potentially, assuming there are would appear to potentially be 3 votes for approval, process it that way. I'm not saying that it would end up that way, because we would only know that at the end of the process. But if there is 3 or more who are leaning to reconsider the item in lieu of pursuing the Fluedger mediation, that is an alternative. It would have to go through the public hearing process where everyone would have an opportunity to give their input. And ultimately, a determination the end result would be presumptively that 3 or more determine that the applicant has met the criteria and granting the special exception appropriate. And then we would never go through the Fluedger process.
Well, that's the question today, then. The question is whether to proceed to the mediation or to go back through the process. That's
Mr. Chair, if I may, to answer your question, you wanted to know our input on the letter or the email that we got last night. I took it as a first step in negotiation. You know, as with any negotiation, you come out with what you want and you work from there. If anything is prevalent, that's what Major League Baseball is trying to go through right now. So I did not take it as it's this final. I think it would be a good decision to go to mediation, to have discussions, to bring it back so that the public can comment on it, and we can vote from there.
And I'll just say too, you know, I mean, because when you read the letter, I think you know, it would be, there's something to be gained by going to mediation over just giving them what they're asking for. That right now we're at a situation where, particularly on their part, and you can see this in the letter, they've been listening to their attorneys for years now, and they're taking their attorneys' opinions, I think, as sure bets, that they think they're going to win all this, that they think they are in the right. That I think going to mediation will allow someone who's more neutral to talk to them besides just their attorney and just maybe opposition they're getting from people who are not legal. So I think that not going to mediation would be giving up whatever the potential negotiated settlement would be, instead of just giving them what they want.
okay. Full for mediation.
I think this whole issue is extremely complex, and to not participate in the mediation, I think potentially denies the town some opportunities here for significant concessions. I do agree with Councilor Veach, and I've talked at length with our town attorney, to share all those, that negotiating strategy this morning would put us at a tremendous disadvantage. Well, I think it's appropriate for us to not do that at this time. For an example, I mean, the existence and the propriety and how it was founded of the critical wildlife area has been brought into question through this whole process, and that has me greatly concerned. And I think through this mediation process, John can flesh that out, work through that, have conversations with the applicant, attorneys, and I think we need to have some clarification of these broader issues in order to vote intelligently on the settlement. And I think this mediation process could be very, very helpful in that. And again, there are significant concessions that could be exacted on behalf of the town if we allow the process to move forward. It may not bear fruit, and that's fine too. Hopefully both sides will be able to work through this, but if not, then we'll know that, and then it seems like we're missing an opportunity at minimal cost to act some significant concessions and, quite frankly, some clarity on some issues that have been bantied about here through this whole debate that have got a lot of folks very concerned about the sheer existence of the critical wildlife area. So I think I would be supportive of this process moving forward.
Those are interesting points you bring up, Jim, about the
Answers.
They're not
That's why
gonna be very
I'd like to
pleasant.
get some clarification.
matter of fact, I spoke with the lead counsel for Department of Environmental Protection of Tallahassee. His name is Justin Wolf, also the acting head of the DEP. He questioned that very matter, how it was formed originally, and the existence of it moving forward. So, and also the attorney that worked on the case, Betsy Hewitt, I also spoke with her about it. They're both in agreement. The very existence of that is in jeopardy. So, bear that in mind.
And that gives me great pause.
Yeah, it does, myself as well. But be that as it may, there's two. Dan, how do you feel about moving forward with the mediation?
Yeah, I agree with both Jim and Bill about moving mediation, and I'm comfortable with not discussing a game plan. I'm comfortable with John moving forward with the conversations that we've had to date.
Good. Is your direction, sir?
I didn't vote.
Well, I know how you stand, Vice Mayor.
Well,
Go right ahead. Go right ahead.
I would just like to respond to the threat to the CWA. If the CWA was not created appropriately, any landowner in that area can do the same thing, come in and ask for a bridge across the lagoon right next door. And if they wish to, they can also threaten the existence of the CWA. If it wasn't created appropriately, our bending on this litigation does not necessarily save it if there was a flaw there in the creation in the first place. You can't save it from the next person down the road who wants to build something out there. So using that as a reason to fold is inappropriate in my view. I think that we need to consider it in that fashion. I'm in favor of going forward with mediation as the least repugnant of the options available.
Mr. Mayor, if I could clarify, I'm not saying we should fold, Madam Vice Mayor. I'm saying this is an issue that has been raised and bantied about by on both sides that needs further clarification because if we can, as part of the settlement agreement, help resolve some of these issues, that could be helpful. I don't know the answer. I'm not saying it's a reason to cave.
We cannot protect the CWA as part of this litigation. That is not possible.
Well, if the mediation it results in a settlement and does not result in further litigation, which could then relitigate the CWA, that could present problems that may not otherwise come up. I'm just saying these are things we need to think about. That's all I'm saying.
And I agree, you know, but you know, the part of the legal process is that everybody can have a legal opinion. Our attorney can give an opinion, their attorney can give an opinion, all of us can, well, not a legal opinion, but anyway, an opinion, but it isn't, it's up to the courts to resolve. So if you really want that clarity, you have to go to court, and that's a very expensive way to get clarity.
We may not want to do that, yes.
I agree.
I think if we've come to the decision that we want to go forward with the mediation, we need to pick somebody.
Too. And I'm going to go back on my strategy that the idea to go to mediation and the best chance of any kind of settlement or report to get accepted by council is that if we get the best, most beneficial settlement for us. And I would propose that we send Rexann, if she agrees to go to the mediation because of her legal experience, and that I think she would fight for the best possible settlement that we can get.
I'm willing to go.
Anybody else have an opinion about that?
Look, if I might ask a question respectfully of Madam Mayor, if you, in private, have conversations with our town attorney and you collectively that the council's direction is a little bit different than yours, maybe not significantly, but different, you're obviously more than willing to subscribe to that as in terms of the mediation process. Is that
I
fair?
can take part in a mediation and come up with an agreement that I don't necessarily endorse.
That was my
I have
question.
that ability.
I know you have, I know you have that ability, but I just wanted to make sure for the record that was indeed the case, that you be comfortable with that, I guess is a better way to say it.
I don't think it's, if people are uncomfortable with me being the only person there, I don't think John would rule out that two of us could go.
You mean the two of us?
Rather than just sending one town council representative, we could send two town council
Well, I
representatives.
have-
He said it's a team.
Well, we still have issues with sunshine. The moment that you send more than one, the sunshine law becomes implicated, particularly to the extent that there are conversations during the course of the mediation where the item is likely to come back before the council as a whole, where the resolution of that dispute or those issues would require interaction of the two council members that have been designated to attend. We
See
never
your
can
point
get
in the
away from
abundance
the
of
sunshine
counsel.
law. That's the problem.
See your point.
Very frustrating. But
The vice mayor and myself have obvious disagreements in this case. Not just the way we voted, but our feelings towards what's going on out there. So I'm going to suggest that either one of us would probably maybe not be the best choice. I'm going to suggest that you go, Jim Atterholt. You be our representative. You're a little bit more neutral on this so far, is what I can see, and you would be my recommendation.
Appreciate that. I have complete faith in the vice mayor's ability to do this and probably do it I don't say probably, she's much more knowledgeable than I am in these areas. So this issue is going to have to come before us. And she's already said publicly that if it's a settlement that she's not entirely comfortable with, she'd still felt it was in the collective interest of the council's directions to our town attorney that she would still proffer that to us and I think make that available. And I trust her to do that. So I appreciate that. I think her background in this area is going to be very helpful. The applicants aren't going to be thrilled to hear that she's our representative, and that's okay, because we're trying to negotiate the best deal possible for the town. So I appreciate that, Mr. Mayor, but I think it's appropriate in the sense, but I want to restate there's some broader issues involved here, ownership issues, CWA issues. We need to solve. And it would be much better to solve them in a structured mediation than in court, where the litigation risk to the town gives me great concern. And if we can resolve this amicably and reserve significant concessions for the town, I think everybody would win. Cooler heads would prevail, and hopefully we could resolve this. As the mayor said, we've got significant conversations on major development projects for this town that could be placed in jeopardy if this litigation risk is deemed significant. And I know there's differing opinions on that. But at the same time, we want to preserve this CWA. We want to do all the right things. And I think having an aggressive mediation process, again, John, if you would, if the mediation process is unsuccessful and the applicants do litigate, that does not preclude additional settlement talks, correct?
And no.
Have a much better idea as to what the litigation risk and exposure to the town would be at that time as well, fair?
Correct. We also have the benefit of then being able to have a shade meeting, in addition to the fact that under rules of civil procedure that would govern any such court action, we're going to be ordered to mediate again, once again. I commit to each and every one of you. I welcome the assistance and the involvement of the vice mayor in this matter, but that does not mean that I will not keep each and every one of you informed of everything that happens at every step of the process. So I have input from each and every one of you along the way, and to keep you informed of what's happening. And that certainly is my commitment to you all, as I would in any similar situation. But I do look forward to working with the vice mayor and hopefully bringing a settlement that all parties potentially can live with. And all your points are well taken and received and acknowledged.
Okay. Okay, so that pretty much concludes what we're after here today.
Thank you.
So let's, without any objection, our meeting was supposed to start at 10. Let's take a 10-minute break, and then we'll come back and start the meeting.